Welcome, folks. Thanks for being here. As we get settled, I'm going to launch a poll. If you can take a moment to fill that out, tell us what area of the arts you work in, assuming that you are an arts worker, and tell us a little bit about your understanding of your rights as a worker. That would be very helpful. Um, I'm going to jump in as people join because we have a lot to cover today. I'm Elsa Hiltner, Director of Programs for Lawyers for the Creative Arts. If you don't know about Lawyers for the Creative Arts, and I should preface this by saying this is a partner program, so you might have registered through the Arts Alliance, you might have registered through Lawyers for the Creative Arts. But Lawyers for the Creative Arts is the legal service nonprofit that serves artists and arts organizations across the whole state of Illinois. We have a few different areas of programs. I will also be dropping links in the chat once I'm done talking. But we obviously do lots of live educational programs like this. This is actually our 50th program of the calendar year, so yay, 50. But we do a lot. We cover a really wide range of legal topics. We really try to hit every legal topic that artists engage with in their artistic practice or their daily lives. The two areas we don't cover are family and criminal law, but we can usually send you to another legal service organization if you have questions on those topics. We also have a pretty robust video library of on-demand programs. We're recording this session today. That'll end up in that library too. Please take a look at what we have on offer. If you need something, you can't find it, please email me. I'm happy to help direct you in the right direction and send resources your way. We also have pro bono legal referrals. So artists and arts organizations in the state of Illinois can apply for pro bono legal referrals, which will pair you with a free attorney who can help you with whatever body of work you're dealing with. And then we have office hours, which is a very helpful helpline. You can sign up through our website. It is free. You get a 15-minute call with our on-staff attorney, Weston Dombrowski. And it's a great place to ask questions, kind of get your bearings, figure out what the terminology is for your legal issue, what the next steps might be, if there's some resources that we have, or if that pro bono legal referral is the right choice for you. So please use that when you need it. And then just want to highlight some of our upcoming programs. Obviously, today we're talking about Worker Rights 101, but we have lots of other things coming up and there's more on the calendar. So please take a look. We add new things almost every single week. And then thank you to our sponsors for allowing us to offer these for free. And then I wanted to just highlight this data from the Chicago Art Census. Chicago Art Census is an artist-led initiative that surveyed about 3 years of data, kind of pre-pandemic, about artists' lives and work experiences. And I thought that this was very interesting. And I'm going to end our poll so we can kind of compare. Here we go. I'm going to share the results so that you can all see it too. But just to compare, I think we had like 30% on this said they always understand their rights. I have questions about the people who think they always understand their rights because there's a lot of different topics, as we will find out today. But in our poll, we had about 23% say they often understood their rights, and 62 say sometimes, and 8% said never. So thank you so much for filling that out and sharing that. And I really recommend diving into the Chicago Arts Census and looking at the rest of the data because it's pretty fascinating. And I'm going to hand it over to Sasha Antenko. Do you want me to do housekeeping before I hand it off to you?
Yeah, go ahead and
Okay.
do housekeeping. We can flow. Thank you.
So we are in a Zoom webinar. We have Q&A options for you. If you go to the bottom of your screen, that's at least where it is for me. There's a Q&A function. Please drop your questions in there. Anytime you have a question, you log it in there. We will kind of take questions at the end, possibly pause throughout, but we'll get your questions answered. I did want to highlight that you can ask anonymous questions through that Q&A function. Lots of people use it. It's very helpful for topics like this. If you feel a little weird having your name next to it, it is truly anonymous. Even I, who am running the webinar, do not know who puts those in. So please use that if that's helpful to you. There will also be a post-event email that goes out. Hopefully it'll go out tomorrow. If not, look for it Monday. That will have the edited version of this video along with a bunch of resources that are mentioned today and some resources that Alison Dickson has put together very kindly for us. That will have a survey questionnaire for you so you can give U of I some demographic information for their funding. So please fill that out and get all those wonderful resources. And then just one last little thing, just so folks know, the chat function only goes to us. We will try to grab questions from there if it ends up there, but you cannot chat each other. So please use the Q&A when you can. All right, thank you. Off to you, Sasha.
Salsa. Hi, everyone. My name is Sasha Ongtenko. I'm the Program Director, Creative Workers at Arts Alliance Illinois. For those who don't know us, Arts Alliance Illinois builds the creative sector's power through advocacy and connection to resources to improve the quality of life in communities across our great state of Illinois. Our members represent the spectrum of individual artists, creative businesses, nonprofit organizations, and the role we play is we work to ensure that both members and our larger creative community have what they need to thrive here in the state. So if you're not a member, we'd love for you to join. Just pay what you can. There's no barrier to entry. We just really want more in the field standing with us, especially around creative workers and economic stability. And so you've seen on the slides that Elsa's going through. We've also launched our help desk back in during the COVID-19 pandemic. There was a lot of need. And so fast forward to today, we really wanted to provide more resources and programming, including today's webinar in partnership with Lawyer for the Creative Arts, to support creatives to navigate complex government arts funding, and also various public systems for resources and support, career development, and the like. So please visit us at the help desk. It's an online portal and you can bring all your questions. And hopefully there's a lot of topics and content today, so if there are follow-up questions, you can visit us at the help desk as well. And so with that, I'm so pleased to introduce our presenter today. Alison Dickson comes to us as a labor economic researcher and senior instructor in the School of Labor and Employment Relations at the University of Illinois, Urbana-Champaign. Alison's efforts have led to the first curriculum ever developed in the U.S., and there's a fourth edition that was released. I think it's a fourth edition now, correct, Alison? It's entirely focused on connecting workers' rights education to the workforce development community and programming, which is something that Arts Alliance is really diving into to make sure that access and that their artists can be included in the workforce system. And so Alison has done a lot around job quality and policy impacts pertaining to low-wage labor markets and wage theft, combating that and improving job quality across various industries. And so today, we're excited to welcome Alison to really get at the importance of education around everyone's rights. It's going to be high level today. There's a lot to cover, but I think the post survey will allow us to also understand if we can dive into future topics and future webinars if there is a great desire to understand a little bit more. And so we hope today everyone walks away building their voice and literacy and some of the worker empowerment issues that we believe are essential for job success and stability, because we know that today's artists need it if we are to have a thriving arts and culture sector. Alison, take it away.
Hi, everyone. Super excited to be here. I'm going to share my screen. I have a lot to present, and this is, going to be a drop in the bucket, like Sasha says. So please, there's going to be a couple of points during the presentation where I'll open it up for questions. So please put questions in the chat box, but also please feel free to email me if you have any other issues or things you want to discuss afterwards. Let me share my screen. All right, can folks see that? Great. All right, it's a short introduction, couching my presentation here. Just real quick, I am not an attorney. I have been doing this work for a very long time, and I feel pretty confident in my ability to discuss your rights as a worker in Illinois, but please don't construe anything I'm saying as legal advice. And my university bosses make sure that I share that with you. These slides will be available, and so you can also access my email there if you'd like. So today, I am going to tell you a little bit about who we are, just kind of set the table about the state of work and workers. I'm going to use 3 different scenarios, or actually 4 different scenarios, that I think kind of get at some of the issues that are important to all of us, but I think especially important for folks on this call. These are scenarios I think that can be widely applied. They're not necessarily arts-related jobs like in specific, but it's also kind of a recognition that many people who are doing this work have second jobs, right? And so just keep that in mind. And I also want you to remind me if I forget, there is going to be a form, which Elsa, I think also you could put in the chat now, that will link to just kind of your information. If you add your email and some demographic stuff, I'll send you a list of, or a link to the Google Drive folder that has resources. I wanted to mention that in this folder, there's going to be a whole bunch more resources than I even mentioned in my presentation, but also a bunch of coloring pages that are really cool. One of them is the one that's on this slide. The artist Ricardo Levins Morales created all these coloring pages for us when he collaborated on the development of that curriculum that that Sasha mentioned. So just I like to have coloring pages. I know that oftentimes doing presentations, especially for adults who haven't been in school for a long time, can be hard for folks to really engage. And so coloring is one of those ways, right, that we have stay active in our listening. So a little bit about who we are. Our program, the Labor Education Program, was established in 1947. It's part of the School of Labor and Employment Relations at the University of Illinois. We serve as a statewide educational and research program with offices in both Champaign and Chicago, and we house a number of vital teaching, research, and leadership development programs aimed at fostering economic and social justice for Illinois workers. Our core teaching objectives across numerous program areas aim to provide workers with the knowledge and skills necessary to promote equitable workplaces, enforce worker rights, build effective and democratic unions, develop future worker leaders, ensure a safe and healthy work environment, and advance economic justice. We have this amazing repository of photos from the last 80 years, and some of them are just so cool, these old-timey ones. And so I've been going through it recently, and I added a few, just I thought folks would appreciate them as well. Through our statewide extension programming and non-credit classes, we annually educate over 5,000 workers about their rights on the job and best practices for improving working conditions and job quality. In addition to being educators, we are also economic researchers. The Project for Middle Class Renewal, or PMCR, based on our program, is dedicated to improving conditions for the working class. Our mission is to enhance public understanding of economic and worker issues through research, analysis, and education. We aim to develop policies that tackle poverty, ensure fair representation for all workers, combat discrimination, create stable employment opportunities, and promote middle-class wages. Each year, we release important research studies and host educational forums on labor and workplace issues. And with the slides, you'll be able to click on different hyperlinks. There's links to these program areas. On this particular little icon of this worker rights for workforce development, it's that curriculum that Sasha mentioned. So if you click on that, you'll be redirected to our website where you can download this 2-volume First in the Nation curriculum for free. So workplace violations, we know that they affect the lowest wage workers in particular, who are least able to risk losing or quitting a job. Wage theft or not paying workers the money they are legally owed causes families to fall below the poverty line and strains social safety net programs by increasing workers' reliance on public assistance. Lost wages not only cheat workers and give unlawful employers an unfair competitive advantage over legitimate businesses that play by the rules, but they also cost Illinois residents lost tax revenue and decrease consumer spending in local neighborhoods and businesses. Yet, despite this epidemic, basic workplace rights and laws are typically not taught in high schools or higher education, and employers have little obligation to disclose worker protections other than relevant health and safety information and posted notices of employment laws in common spaces. These struggles are intensified by a confusing patchwork of laws, different minimum wages, paid sick leave, anti-discrimination laws, all based on where you work. Here I've provided a snapshot of the very real differences that exist in labor standards between Illinois and our neighboring states. So why do you think it is? I'm going to ask questions, and it's a little bit rhetorical because I'm asking them and then answering them, so bear with me. Why do you think it is that the minimum wage in Illinois is more than double what it is in Indiana, Wisconsin, and Iowa? You might be tempted to answer that it's because the cost of living is higher in Illinois. And while that is often true, especially when we look at the cost of rent in some places, as well as property tax bills for homeowners, the cost of living in Illinois has little to do with why we have higher minimum wages. Worker rights are stronger and the minimum wage is higher because we have a larger percentage of workers in Illinois organized into unions and with other community groups, pushing our politicians to better balance the playing field between workers and employers. The worker rights difference in Illinois has profound implications beyond just minimum wages. Over 100 years ago, American children regularly worked long hours and night shifts in dangerous occupations for much less pay than adults. Photos from this time haunt our imaginations as we get a glimpse into the lives of kids like 5-year-old barefooted Manuel standing on a mountain of oyster shells in Mississippi in 1911, or children hard at work at midnight in a glassworks factory in Indiana in 1908, or the dirty faces of young boys in a coal mine in Pennsylvania in 1911. In the subsequent years, child labor laws were enacted and regulations were established that determined what types of jobs youth could work in, what hours of the day they could work, and how many hours per week they could work during the school year. More than 100 years later, we are seeing a major rollback of many of the fundamental protections we have against child labor. Once again, we are seeing children working night shifts in slaughterhouses and during school hours as roofers. Some of the most profitable corporations in the US regularly employ child labor in an effort to cut labor costs and trample any complaints about working conditions. So let's get started. These are the scenarios I was mentioning in the beginning. And just to mention, these are all scenarios, things that I've heard from students along the way. Obviously, I changed their names and the employer names, but this is all kind of ripped from the headlines. So here's a scenario that happens on a daily basis across the United States. Ryan of Fast and Easy Painters hires a few painters to help him paint a gallery space for a new art installation opening soon in Naperville. He says they'll pay them $20 an hour and that they must start work on Monday morning at 8 a.m. On Thursday, one of the painters, Marco, slips and falls off the scaffolding and breaks his ankle. Ryan claims Marco is responsible for his medical bills because he hired him as an independent subcontractor. Is this true? So I'm going to let you know, most of these scenarios are kind of trick questions. And this one in particular, because a lot of people experience this type of worker rights violation. No. Per the Illinois Department of Labor, in this scenario, Marco is being misclassified as an independent contractor, robbing Marco of money and workers' rights protections. Marco is entitled to workers' compensation because he is an employee. And per the Illinois Workers' Compensation Commission, 100% of Marco's medical bills will be covered because in Illinois, workers' comp is a no-fault system. We will explore Marco's situation in more detail, but it's important to keep in mind that the issues he faces affect many different workers and are common in many different workplaces. The strategies he must use to protect himself are the same ones that workers everywhere need to use to enforce their rights. Marco's situation covers several issue areas. The first is the difference between independent contractors and employees. An independent contractor is a worker who makes arrangements with a customer or client, brings their own equipment, sets their own work schedule, and carries their own insurance. Independent contractors often work on their own as their own bosses. Based on the facts provided to you in the beginning, we know that Marco is legally an employee, not an independent contractor. How do we know this? Because in this scenario I gave you, Ryan maintains control over Marco's working conditions. Ryan determines the rate of pay and work schedule. If Marco was truly an independent contractor, he would be in control and would let Ryan know how much he would charge for the job and when he could start work. Knowing the difference between employees and independent contractors is important for understanding the next issue, misclassification. Misclassification occurs when an employer claims their worker is an independent contractor when legally they should be an employee. For example, a catering company classifies its servers as independent contractors, even though the company sets the pay rate, determines the work schedules, and provides the food and the equipment. If the workers are called independent contractors, the company does not have to follow many important workers' rights laws. They do not have to pay overtime or legally required benefits such as unemployment compensation or workers' compensation. They also do not make deductions for taxes or Social Security. The worker loses money and the protections of labor laws. The next issue area is workers' compensation. Workers' compensation, or workers' comp, is an insurance system that all employers are legally required to carry to cover employees who are injured on the job. Workers' comp covers all work-related injuries, regardless of fault. Marco is an employee and is entitled to workers' comp benefits. In Illinois, workers' comp is a no-fault system and pays for 100% of medical bills plus lost time and money for a worker's pain and suffering. If you suffer an injury on the job, you're typically entitled to compensation for the damage to your body as well as your future lost wages. But depending on the state in which you work, benefits for the same body part can differ dramatically. This video is like 30 seconds. Hopefully it's going to work, but let's see.
There's no sound on it, but I think when you did the screen share, you didn't click that little pesky button that says share sound too. Do you want to reshare or I can
There's actually, the only sound is just music because it's,
oh,
unless you, if,
perfect. Proceed.
okay, sorry. Apologies for that. I don't think I have anything else that I'm sharing that will need that, but maybe we do. Pretty damning. That link to this ProPublica report, I have it at the end of these slides as well. It is these amazing infographics where you click on your state and you click on different body parts and you see how much your body part is worth compared to other body parts. In Illinois, our body parts are valued very highly, but in places like Alabama, not so much. So another important issue area is wage theft. Wage theft or non-payment of all owed wages is illegal. When an employer refuses to pay you the wages you are owed, they are violating federal and state laws, in addition to applicable county and municipal wage laws. And it's important also to know you have the legal right to be paid for your work regardless of your immigration status. In order to protect himself and enforce his workers' rights, Marco needs to collect important information and document his working conditions. This documenting work needs to start from the moment he's hired for the painting job. It is vital that Marco keep a record of his work hours, note the address of the work site, as well as the gallery owner's contact info, if he can get it. He should also collect his coworkers' contact info, such as their cell phone numbers, in case they were witnesses to violations or maybe experienced the same violations he did. Additionally, he should keep track of any hospital records so that he can apply for his workers' comp benefits and keep his work and keep the money he's owed or receive the money he's owed. But what should Marco do if Ryan disappears? Perhaps Marco wasn't able to learn Ryan's last name, or Ryan's phone has been disconnected, or he can't even find the company Fast and Easy Painters with an internet search. Here's where it's important for Marco to make use of an additional strategy to protect himself and take a photo of Ryan's license plate number. With this photo, Ryan can absolutely file a claim with the Illinois Department of Labor and fight for what he's owed. So I realize this seems like a little bit kind of out there and outrageous, but once again, you know, especially when you're working in the kinds of jobs where you might have lots of different employers and you're traveling around, there are so many shady bosses out there. There's a reason why we talk about these violations having kind of hit epidemic proportions. And so, you know, making use of all these tools, even just taking photos of license plate numbers is incredibly, incredibly important. And so these lists of kind of these strategies are something that in any job one needs to be doing. So after each scenario, as I mentioned, I'm including a short list of additional resources that relate to what I've discussed. So quick reminder just to fill out that Google form at the end of the presentation so you can access all these additional resources. The links to the videos will take you to a YouTube page, which includes a number of other cool videos that you might also enjoy. So here are just some additional good resources where you can find out more about these laws, and then some readings that I thought are interesting and useful. Should we stop there for a minute if there are any questions?
So we don't have any questions right now, but folks, please drop them in the chat whenever you can. And I think just want to reiterate that that worker classification thing is important for artists to know about and for arts employers to really understand versus just doing what the industry norms are.
Yeah, and I think, you know, with that situation with Marco, right? It's kind of focused on this workplace injury, and clearly there's a lot of expenses when you're talking about hospital bills and then, you know, kind of long-term health issues perhaps. But there's so many other issues, right? There's the taxes, there's the access to unemployment benefits, there's getting overtime pay, there's just having protections against like anti-discrimination provisions, anti-retaliation, ability to organize a union. All these worker rights really only apply to employees. And so this is where, you know, it's so important in any job to be, you know, kind of looking who is controlling this situation. Am I truly an employee? Am I deciding, you know, with my expertise, I'm taking this job, when I can work, how much I charge, or am I just kind of following the lead and of the employer and you know, doing exactly what they say that needs to be done? And I understand there's a lot of gray area here, but this is why, you know, especially if you're not even sure, it's so important just to be documenting and keeping track of all these things so that in the event there is an issue, you have the resources available to protect yourself.
Yes, and I will just add too a plug for Lawyers for the Creative Arts or free services. If you are an organization that is not sure if you're classifying people correctly, please come to us for a review. And if you're a worker who has questions about how they're being classified or is dealing with a workplace injury or any other topics that we'll cover today, please come to us. We're here to be a free resource to help you and set you in the right direction and give you some actionable info. So don't hesitate to reach out.
Great.
Oh, we just got a question.
Oh, sorry.
You're good. Regarding overtime pay, as a full-time employee in Missouri, what does this mean? Because you meet the FLSA criteria for an exempt employee, you waive overtime entitlements and will not receive overtime pay for hours worked over 40. And I will say this question could be for folks in Illinois too. The question is, what does that mean and how is this legal?
That's a great question. So overtime laws, for the most part, are covered under federal labor laws, the Fair Labor Standards Act, FLSA. And so that means that for most workers in our economy, certainly anybody who's getting paid hourly, time and a half pay kicks in after 40 hours in a given week. But there are important exceptions to that law, and one of them is salaried employees, right? And so there's a threshold that determines whether or not you can be exempt from being entitled to overtime pay. And under the Biden administration, that exemption or that threshold went up to 40 something thousands. Apologies that I don't remember the exact amount. It was previously capped at 23,000, which is kind of insane. And so that means that even if you are a salaried employee, if you're earning an annual salary below that threshold, you are entitled to time and a half for all hours you work over 40. Where it gets dicey also is that some jobs, let's say like take a manager at a fast food restaurant, right? They will be paid salary, and an employer will then, expect them to be working over 40 hours in a week and not receive overtime pay. But when you look at their job duties, are they really, kind of in the same boat as what we tend to think of salaried employees, kind of more in professional positions? Probably not. And so really, figuring out what that threshold is, and I don't know what it is in Missouri. Certain states have different levels that are that exceed the federal limit. That's important too, because I've seen employers like have their salary threshold be like $10 more than what the federal requirement is, and that's a red flag that employer probably is not particularly concerned with other important employment and labor laws. So to answer your question, salaried employees for the most part are not entitled to overtime pay. That's very problematic, clearly, because many people work over 40 hours in a week. Generally my presentations are less than optimistic because the US has relatively very weak workers' rights laws. So
good to know them, though.
okay. Sorry,
Gives us information to advocate.
Yeah.
We have two other questions, if we can do those, and then maybe move on. And thank you all for dropping your questions in. It's very, very helpful, and these are great questions. When you say no fault, can you talk a little bit more about what that means for workers' comp? And the additional part of this question is, are they allowed to make you take a drug test and deny it if you fail? And I think added to that, like if you have, your own medical issue that caused the accident or other kind of extenuating circumstances, what does that no fault entail?
So awesome questions. And I'll just preface this by saying that like all the workers' rights I'm talking about today, I think are for the most part things that you don't necessarily need to seek legal representation to win these cases. You make use of awesome legal resources for sure, but these are things that like, one can go to the Illinois Department of Labor or the Illinois Workers' Compensation Commission and well, sorry, let me take a step back. Illinois Department of Labor or the Illinois Department of Human Rights and file your own claim and take care of it yourself. Workers' comp is one of the only provisions that I would say, if you're seriously injured at work, it's a good idea to talk to an attorney. And you don't want to talk to the attorney that's like on the billboard, like, did you get injured at work? Not that guy. You want to talk to somebody that ELSA recommends, or look at the attorneys that are representing IATSE. Those are the people that are going to look out for your best interests. So getting to the questions. So no fault means that it has, even if you were doing your job, let's say carelessly. So Marco is on the scaffolding, but he is not using his harnesses properly, right? Or maybe he didn't even have PPE. Those are all the employer's responsibility to begin with. But if he's doing his job in an unsafe manner and he gets injured, workers' comp still covers him. And so the reason why workers' comp has this kind of like broad, kind of a wide range of coverage is because in exchange for having this protection, workers give up their legal right to sue employers. And so we have workers' comp, and it's kind of wide reaching, but then you can't sue. And so So no, a fault in that case would be if, let's say, Marco was high, right? Or if he was drunk, right? Any of those things would be considered fault. In terms of an employer requiring you to get a drug test, they absolutely can require that. And so many large employers, corporations in particular, right, will, if they have an employee that gets injured, they'll want you, that employee to go to their preferred clinic, right? They have a contract with some clinic and they might say, oh, you know, don't worry, we'll take care of you. Go to this doctor, you're not going to have to pay anything. And the worker goes to that doctor, the first thing that happens is a drug test. You know, even if they're not high, but they still have some THC in their system because it's legal in Illinois, that would be grounds potentially for them to get their workers' comp claim denied. Once again, good time to speak to an attorney. But that employer also wants them to go to their preferred clinic because that clinic has the contract with the employer. I mean, it's a fundamental conflict of interest, you know, in terms of like kind of the best care that worker is going to receive. The employer's clinic, you know, feasibly could just say, okay, 2 weeks light duty, you're fine. In Illinois, one of the things that make Illinois' law much stronger than other states is that we have, as workers, we have the right to go see our own doctor and base our workers' comp claims after like off our doctor's own diagnoses. And if you are not satisfied with what your doctor diagnoses, you have the right to a second opinion. In Indiana, for instance, if you get injured on the job, you have to go to the company clinic and you have to base your workers' comp claim off what the company clinic's doctor says, which is really problematic. So in some, if you get injured in Illinois, they want you to go to the company clinic. You probably still need to go because they could, unless you have a union or some other protection, they could fire you if you don't go. So get checked out by them, but then go to your own doctor afterwards, get checked out by your own doctor and file your claim based on what your doctor says. And that's what applies for you for in Illinois.
Great, thank you. Last question we'll do for now is what should you do if you are getting paid in cash? And you know, is there anything that you should document as far as tracking your work and employment and all of that?
So getting paid in cash is probably is you know, a good sign that wage theft might be occurring because then, you know, it seems unlikely that the employer is also making their contributions to the benefits that you're legally owed. You know, at a minimum, make sure you're keeping track of all the money you're owed. I understand, having worked many food service jobs, that, right, if you're getting paid your tips in cash, that's also a great opportunity not to report that income because then you don't have to pay taxes on it. But kind of at the end of the day, what's important is that even if you are being paid in cash, that in itself is not necessarily illegal. What's illegal is if the employer is not satisfying the requirements of the law, right? So extra important if, you know, if you don't have paycheck stubs or anything like that, that you're just documenting that pay and your hours and everything else.
Great, thank you. Great questions, everyone. Thanks so much, and keep them coming for the next break.
Okay, all right, so let's do another scenario. So this is certainly not like arts creative economy focus, but this is for everybody who's got the side hustle, right? So Jeremy, he waits tables at an Olive Italiano restaurant in Peoria. His shift starts at 11 a.m., but his manager insists that he arrive by 10:45 a.m. so that his station is ready for the lunch service. Is Olive Italiano required to pay Jeremy for this extra 15 minutes? Ooh, yes. Oh, now I just realized I do have another video. The answer is yes. And, you know, while 15 minutes might not seem like a lot of time or a lot of money over the course of a week, a month, a year, that adds up real quick. And if they're doing this to their entire workforce, that's nickel and diming your workers, and the employer is stealing a lot of money. All right, I am gonna stop, and then tell me else again how I can reshare and
Yeah, so close your share and then reshare, and it'll let you pick the window. And then there's a little box, usually on the sort of towards the bottom right, that says share with sound. Click that box and then click share, and it should all work.
Sorry, everyone.
You're good.
I've got share settings, advanced. Oh, I do not have that button. That's okay.
Fascinating. Do you want me to I have your slides right here.
Okay, can you do it? I'm sorry
Yep.
about that, everyone.
Let me find the right one. Okay. Okay. Can folks see that okay?
Yep.
Okay, let's start the video.
Anna worked for 5 years for a cleaning company in Chicago, where she was paid $8 an hour, even for overtime hours. One time I worked for 22 hours in a row and was paid only $120. Anna explained, "My boss told me that was all he could give me." She is owed about $1,800 from bounce checks, plus wages she should have received if her employer had abided by overtime laws. Anna is not alone in experiencing these type of workplace violations. In the Chicago area, the non-payment of wages takes a heavy toll on workers and their families. For those workers who experienced a pay-based violation in the previous week, the average amount of lost wages was $50, out of the average weekly earnings of $322. Assuming a full year work schedule, it is estimated that these workers lost an average of $2,595 annually due to workplace violations, out of total annual earnings of just $16,753. In a given week, approximately 146,000 workers in the Chicago area experience at least one pay-based violation, meaning that workers in low-wage industries lose more than $7.3 million per week as a result of workplace violations. Wage theft not only depresses the earnings of low-wage workers, it also adversely impacts their communities. Low-income families spend the majority of their earnings on basic necessities, such as food, clothing, and housing. Their expenditures circulate through local economies, supporting businesses and jobs. Wage theft robs these communities of a portion of this spending, ultimately limiting economic growth.
Great. Should I
Do you want to
reshare
go
now?
back? Do you want to go back to your share?
Yep, if you
Okay.
don't mind.
I
Thank
will
you.
stop sharing that.
Cool. All right, thank you for your help.
Of course.
So this video was made off based on a study that I had the opportunity to work on in 2008. We surveyed thousands of workers, low-wage workers in Chicagoland, and were able to discern that in a given week, just in Cook County, $7.3 million was being stolen from workers. And we only measured 3 different ways wage theft occurs. I'm going to talk a little bit more about what that means, but we can begin to unpack Jeremy's situation with Olive, not Olive Garden, Olive Italiano. I'm not even slick changing these names. Olive Italiano, with these kind of one of the many different ways that wage theft occurs. So first and foremost, wage theft is a crime. If you steal from a store, you go to jail. But employers who cheat their workers of wages often get away with it. So why is that? and what is wage theft? It is being forced to work off the clock, and or clock out early and keep working. It's getting your tips stolen by your manager or your boss. It's not receiving your meal and rest breaks. This is just like a few of the examples. It is, when we think about the definition, it encompasses kind of the illegal underpayment or non-payment of workers' wages and benefits. This is just some of the ways that it occurs, and I think this list is certainly not exhaustive. It's when you're being denied the legally required minimum wage, denied the legally required overtime rate, work off the clock without pay, you're paid late, or you're not paid all the money you're owed, you're forced to share your tips, you're denied benefits that you're owed, you're misclassified as independent contractors like Marco, you suffer from illegal deductions to your pay, or you're denied payment for required training. So when I'm talking about illegal deductions, that would be like if Marco was forced to pay for any of the PPE, so the personal protective equipment. If he had to pay for a hard hat or harnesses, that would be illegal. For Jeremy working a serving job, if he, let's say, the uniform is not necessarily PPE, but if it's something certainly that's specific to a company, so if Olive Italiano has branded shirts that you can't just buy at Target, Olive Italiano would have to provide them for for Jeremy, free of charge. If they deducted a fee from his paychecks for those uniforms that are specific to their company, that would be an illegal deduction. Also denied if wage theft occurs when you're denied payment for required training. Oops. As you can see in this chart, wage theft is a much bigger problem in the US than robbery. Importantly, this $933 million number shown here is only the money that was recovered from federal and state labor agencies. Experts estimate that the real amount stolen from US workers is likely closer to $50 billion per year. So like that $7.3 million I mentioned that we measured in Cook County, right? That was just looking at 3 different types of wage theft, a subset of workers, and it was, in 2008. That is like almost 20 years ago, right? So in 2026 dollars, that's certainly a lot more money. A more recent report by the Economic Policies Institute also attempted to measure one form of wage theft, minimum wage violations in the 10 most populous US states. The authors of this study found that in the states they analyzed, 2.4 million workers lose $8 billion annually to minimum wage violations per worker. That's $3,300 per year. This form of wage theft affects 17% of all workers in low-paid jobs, with workers in all demographic categories being cheated out of their pay. Wage theft is systemic and affects workers across the economy, but it's concentrated in industries and sectors that disproportionately employ Black and Latino workers. Annually, at least 250,000 Illinois workers have $675 million stolen from them by their employers in minimum wage violations alone. Sorry if you hear like an annoying cat right now. It's being loud. So here we can see a list of some of the strategies Jeremy needs to employ daily to protect himself. Jeremy is going to need all this information in order to file a wage claim with the Illinois Department of Labor. And in just a minute, we're going to look at how you do that. But, regardless if he's having issues at work, he needs to be keeping track on his own of his work hours. So a lot of companies have, their own systems for employee schedules. It's important for Jeremy to keep his own system or to take screenshots when, those employer systems are obviously owned by the employer, so they can be manipulated by the employer, but it also means that employees can be locked out of them. So it's important for Jeremy to keep his own records of these things. And it really doesn't matter if you're like old school like me and, with your paper calendar, or if you're more technologically savvy and you do it on your phone, it doesn't matter as long as you're being consistent about it, doing it every day, having accurate information. And here, once again, I think it would be a good idea for him to keep track of his coworkers' contact info. You know, if this is happening to him, it's likely happening to everybody else. And so while he has enough evidence to file a claim with the Illinois Department of Labor, that claim is going to probably receive much quicker attention and be more impactful if he and 6 of his coworkers all file the claim together. So let's keep with Jeremy. So a global pandemic plus polar vortex mean that most of Olive Italiano's business has switched to takeout orders. Jeremy no longer has tables to wait and is helping package customer orders. Before the pandemic, Jeremy was paid a tip sub-minimum wage in addition to his tips. Can his employer continue paying him this way now? It depends. So here, you know, the issue area has to do with kind of like what percentage of his job he's spending doing the packaging versus actually you know, waiting on customers and receiving tips. So under federal labor law, employers can pay tip workers a sub-minimum wage or tip credit of just $2.13 an hour, rather than the standard federal wage of standard federal minimum wage of $7.25. In Chicago, the sub-minimum wage for tip workers is $12.62 an hour, while in the rest of the state, it is $9 an hour. If tips earned do not allow a worker's total earnings to equal at least the minimum wage floor for the geography where they are employed, employers must make up that difference. So in Illinois, if you are in a tipped job, he was in Peoria, and the employer insists on still paying him the sub-minimum wage of $9 an hour, but he's just packaging orders and not earning tips, it is still legally required for that employer to make up that difference. So pay him at least another $6 an hour to make him whole and have him be subject to the standard minimum wage, which is $15 an hour in Illinois. If anybody wants to do a deep dive into why we have these carve-outs, that is a story for another day. It has very racist origins, and you know, these sub-minimum wages kind of are a vestige of slavery in this country, and who was carved out from the original minimum wage laws that were passed. So in reality, we know that these tip workers lose millions of dollars annually because of this legal carve-out. A 2014 review of employment records nationwide found that almost 84% of full-service restaurants improperly calculated wages for tip workers or had committed other wage and hour violations. In reference to widespread violations within industries dominated by tip work, David Weil, former administrator of the Wage and Hour Division of the Labor Department under President Barack Obama, stated that it's baked into the model. It's very problematic. The Bureau of Labor Statistics finds that restaurant workers occupy 4 of the 10 lowest paid occupations nationwide, and recent studies have shown that these workers are at least twice as likely to live in poverty. So just do a quick segue. How are we doing on time? Elsa, I have like 15 more minutes. Is that correct?
We have until 1:30 if we need it with questions. So yeah, you do what you need to do. Thank you so much.
So just want to do a little like segue into some research that we did in 2022, 2023. In 2022, I led a team of U of I researchers collecting over 1,200 surveys of tipped restaurant and bar employees throughout the city of Chicago. And this was really focused on the work experiences of workers earning tips, including servers, bussers, bartenders, barbacks, baristas, and hosts. So the workplaces that that survey participants came from range from high-end fine dining to affordable restaurant chains to small neighborhood bars and coffee shops. Our study and ensuing analysis and report were conducted at the request of the Mayor's Office and the Chicago Department of Business Affairs and Consumer Protections. And findings from the study were used by the Mayor's Office and BACP to justify the ultimate passage of the 2023 ordinance, which had the intention of phasing out the sub-minimum wage that can be paid to workers earning tips in Chicago. Our work with the city was part of this larger pro-worker policy agenda that began under Mayor Lori Lightfoot and continues today under the leadership of Mayor Brandon Johnson. But I'm sure that many who are tuned in here are also aware of the recent very disappointing news of the rollback of this repeal. And just to show you like kind of what we were able to see just in Chicago, our analysis of survey findings identified numerous areas of economic hardship, as well as conflicts between workers' employment and their overall well-being. Additionally, we discerned several violations of different municipal, county, state, and federal work-related laws, including multiple measures of wage theft, hours and work schedule violations, discrimination and harassment, and occupational health and safety violations. Surveyed workers experienced at least 8 forms of wage theft while working in these jobs, including working off the clock, working without pay, not being paid overtime, illegal paycheck deductions, charges for required uniforms, being paid late, tip sharing with management, and an inability to take meal breaks. For example, almost 80% of surveyed workers worked without pay at least once in the month prior to their survey participation, and an additional almost 9% worked without pay 3 or more times in the previous month. Close to half of workers were paid late at least once in the month prior to taking the survey, and almost a third received late pay 2 or more times. Nearly 57% of surveyed workers were required to legally tip out their managers in the week prior to survey participation. And roughly 12% of surveyed workers reported never or only sometimes receiving overtime pay for hours worked over 40 in a given week. When workers depend on tips to comprise significant portions of their incomes, customer whims and preferences lead to incredible power imbalances within workplaces. Workers participating in our survey experienced varied and compounding types of discrimination on the job, including disturbing levels of sexual harassment and assault while at work. More than half of surveyed women and over a third of surveyed men and those identifying by other genders experienced sexual harassment, a form of gender discrimination in the past year. Over 8% of all surveyed workers were sexually assaulted at work during the past year. And discrimination based on a worker's race and or ethnicity affected roughly 23% of Latina workers, almost 16% of Black workers, and over 30% of Asian workers while on the job in the past year. Research shows that while worker pay is critical for job quality, wages are only part of the equation. Workers also need adequate work hours and stable schedules to be able to maintain decent incomes and balance work and family responsibilities. Underemployment and work hour volatility are critical for understanding both worker and household income and general well-being. Together, these two components of job quality can cause workers to not earn enough or have unstable earnings, and then diminish their ability to meet their basic needs and work towards economic mobility. So we saw just that like over half of workers that participated in the survey took additional jobs. There was substantial uptake of different forms of publicly available assistance and disturbingly high levels of housing insecurity, and homelessness. So kind of to explore wage theft more, I've included in the resource folder some additional readings and videos. And I've also have some resources, some links to Illinois Department of Labor and City of Chicago protections. So those will be all in the folder. We're not going to watch this, but when you, if you go to the Google folder and click on these links, you'll be taken to the YouTube page that has lots of cool videos. And this is one that I really like. It's produced by former U.S. Secretary of Labor Robert Reich on the different tactics some employers use to exploit workers. So this goes kind of beyond wage theft. He's talking about NDAs and just other kind of tricks that bad apples use to exploit workers.
Your employer could be.
No, we are not watching you. All right. Maybe take a break there.
Yeah, thank you so much. Okay, so drop your questions in the Q&A when you have a moment. The first question is about the Freelance Worker Protection Act and a little bit about the process of filing and any statute of limitations. So, how long can a wage violation claim for failure to issue payment under the Illinois Freelance Worker Protection Act be filed? Do you have to file with the Illinois Department of Labor first? Is there a benefit to filing with the DOL? Is there a time limit to claim failure to pay overtime?
Great question, and it's important to know that this law specifically it covers independent contractors who are working in this space as well. And I'm sorry I didn't include any. I really should have included.
It's all good. Here's the thing. I'm going to plug in the chat.
Okay, good.
We're doing a program specifically about this next week. It'll cover the Freelance Worker Protection Act, but then also some other remedies that you can do if you have completed or started work without a contract and you have issues getting paid or issues getting credit for your intellectual property. So please follow that link if you need to. But yeah, if you'd like to add anything to that question, please do.
Well, what I was going to say is in the next scenario, we're going to look at the Illinois Department of Labor's website, and there is lots of very helpful information that will directly answer all those questions right there. Under the leadership of Director Jane Flanagan, who heads up the Illinois Department of Labor, she was appointed under Governor Pritzker. There has just been kind of monumental overhaul of that department. She's somebody I've known for well over a decade, has been in this space defending workers. She is a former, she's still an attorney, but she historically represented low-wage workers. And so their website is so easy to navigate now. And even if you're going to their website and it's not specifically the department that handles the issue that you're looking at, let's say you want to know more about workers' comp, it's not technically the Illinois Department of Labor that covers that, but they have a link right there on the homepage of where to go to, and they'll refer you to that other page. Additionally, even if you just call their office and speak to one of their investigator will transfer you directly. So it's pretty seamless. So Elsa, yes, let's just plug your webinar, because I think that there's a lot to unpack with that law. And so I guess tune in for the next presentation.
Yeah, and as Sasha also just put in the chat, Sasha and I are working on a full series of programs. This is the first one in the series. There will be more coming out throughout the summer and, maybe into the fall. We'll see how long we keep going. But we'll be announcing pretty soon a program in July with the Illinois Department of Labor, and they'll talk about Freelance Worker Protection Act then too. Okay, we have a ton of questions, which is amazing. Can employers require unpaid labor if you are salaried and FLSA exempt, like unpaid hours after the 40 hours you've already worked?
Yep. That's the short answer to that. They can. The only exemptions to that really for salaried employees is kind of occupation specific. So if you are working in, let's say you're a pilot, right? That would be an obvious one where it's going to be like a safety issue. Or hospital workers can be subject to different overtime laws as well. Sometimes for hospitals, overtime doesn't kick in till you've done 80 hours in a 2-week period. But for the most part, for everybody else, yes. Take that work home, work for free. It's really messed up.
Can you talk a little bit about retaliation towards workers for asserting their labor rights and maybe what they can do about that?
Absolutely. And I think with the next scenario, we're really going to get into that a little bit more as well. But retaliation is absolutely illegal if you're trying to enforce your right. This is an important exemption or exception to at-will employment. Um, so you can't be fired, or the law states you can't be fired or retaliated against, like having your hours cut or your shifts radically changed or some other retaliatory action for enforcing your rights on the job. Now, here is where, once again, it is so important to figure out what strategies you're going to use to enforce that right. Because most employers are not going to be dumb enough to say that they're retaliating against you, right? They're going to find some other pretense. Um, they're gonna say, oh, but you've been late or you didn't, meet your quota or whatever it is, right? And so um, proving then retaliation becomes a little bit more challenging. And so, it has to do maybe with timing. If you filed a complaint with Illinois Department of Labor and then next week you're retaliated against, that's probably not a coincidence, right? So here it's all these things kind of, it is pieces of the puzzle of how to enforce those rights.
Thank you. Okay, here's the next question. If I hire people to work just one show at my theater company, I'm assuming this is, actors or stage managers or, what have you. If I'm telling them the specific times I need them to work for rehearsals and shows, to us, they're independent workers because we're just bringing them in for one show. It sounds like we need to do a W-2, even if it's just for the month they're working for us. Uh, do you have any suggestion based on that scenario if this would be a W-2 worker or an independent contractor?
Would probably talk to Elsa. Um,
This is
because
a
I
good.
think this is really I think probably a lot more details are needed in order to answer that question, right? And this is, and misclassification is such a complex issue. This is why, Uber and Lyft and delivery companies are being sued all over the place because when you look at the control they have over their workers, one could argue that those workers are clearly employees, but legally they're being called independent contractors. And so I would recommend you reach out to Elsa's
Yeah.
organization. Sorry, I'm not trying to
Yeah,
just
no,
bash on it, but
that's perfect. Yeah, and please have your processes and classification reviewed with us. There have been some local cases where actors have been classified as independent contractors and have been found to have actually been employees. So I would say don't just do what the norms of the industry, what everybody else is doing. Make sure that you have an attorney look over what you specifically are doing in the cases of your organization and the work and how you're hiring people. So please come to us. Okay, now we have several questions, both about non-competes and NDAs. Uh, Mostly are NDAs and non-competes legal for being, like can they be required for either an employee or an independent contractor? And if you're an independent contractor and you hire extra folks, do you have to pass that NDA that you've signed with the client onto them? That was kind of a lot.
um um the law, we don't have very good laws protecting workers with NDAs, and so that's kind of the short answer. I don't know the answer to the second part about having to pass it on to subcontractors, so sorry. um Apologies. I'm
No,
not gonna give
I
you
mean,
legal advice, and I'm like, I don't know enough
we're trying
other
to
than
cover everything in worker rights, so do not
Sorry.
worry. And, I think we were talking before we started, and just to pass on to all the attendees, this is a survey session. Allison was saying, she teaches full semester courses on this. People go to law school for years and years for this topic. So we're really trying to like, give people some information and also get you thinking about what questions you need answered for your own personal, working conditions so that you can come back to us and do a deeper dive and like find the information that you need. So it's really, we are trying to answer as many questions as we can, but also trying to get you to think about what questions you have and then follow up with us. So yeah, thank you for all of these.
Maybe, Elsa, I think with the next scenario, we kind of get into a couple of other important issues that I just wanted to touch on. So maybe I could just go through that scenario and then do any all the remaining questions. Is that
Yeah.
okay?
Perfect. Thank you.
All right. All right, for our last scenario, Marnie. Marnie works as an office assistant for a medical office in Schaumburg. Traffic on the Kennedy is especially horrible one day, and she calls her employer to let them know she will be 15 minutes late to work. When she arrives at her office, she is fired. Can Marnie collect unemployment insurance? Probably. But before we discuss unemployment benefits, let's take a step back first. So without knowing any other information than what's provided about Marnie, what I provided here about Marnie's work, is it legal for Marnie to be fired? Yes. If we assume that her job isn't covered under a collectively bargained union contract, she is likely represents the part of the 85% of Illinois workers that are at-will employees. Is it legal to fire her even though she called her employer to inform them of her delay? In other words, she wasn't no call, no show. Is that still legal? Yes. With no union representation, Marnie is still an at-will employee. You can be fired pretty much for any reason at any time, for a good reason, bad reason, or no reason at all, unless it's an illegal reason like retaliation or discrimination. So can Marnie be legally fired if she's worked there for many years and is nearing retirement? Or what if Marnie was told she was fired for arriving late, but she suspects the real reason is related to age discrimination? How can she prove her case? So this, I want you to just sub age discrimination for retaliation. Really, it's exact kind of same line of thought about strategies you'd need to employ. So how can she prove her case? There's a pretense, a legal pretense being given to why she's fired. And especially, I can imagine for age discrimination, while this is super bogus that she's fired, if she's nearing retirement, it's going to probably be hard for her to find another job. So it might be worthwhile for her to fight to get her job back, right? So if the underlying reason for her being fired is due to age discrimination, then yes, it is illegal for her to be fired. But this is where we really need to think outside of the box for proving her unlawful termination claim. She could do this by employing some of the other worker rights documenting strategies we've been discussing. Perhaps Marnie senses there was discrimination because of discriminatory comments her supervisor had said in the past. So each time this occurred, she would have needed to keep a log of the date, time, what was said, were there any witnesses? So, if it's just these offhand comments like, oh, are you planning your retirement party yet? Or like, just something stupid like that. Those don't necessarily rise to the level of being illegal, but every time that happens, it might be a good idea to keep note of it, because then if some sort of unlawful termination or something else happens, those would be she would use to build her case. Same thing could be true for sexual harassment or any other type of discrimination. Another tactic would be for her to show disparate treatment. So in other words, does she know of other employees who have been late but weren't fired? Is she older than these employees? It's vital that Marnie keep a record of her past performance reviews and attendance records so that she can prove her tardiness wasn't a regular occurrence and that this firing was due to discrimination. But going back to the question of getting her unemployment benefits, in Illinois, an employee is generally entitled to collect unemployment insurance unless they were fired for willful misconduct. So based on the information I gave you, it doesn't seem like this is the case for Marnie. Willful misconduct would be being intoxicated, stealing, those are all willful misconduct. Based on the information I gave you, it doesn't seem like this was the case for Marnie. So in the event that it's not illegal discrimination, she really just was fired for, this petty BS, right? What can she do if her employer is fighting her unemployment insurance claim? So this is something that, happens a lot, especially, kind of is the tactic of some of the largest corporations in our country is to fight unemployment claims because it costs them money when a company is drawing unemployment benefits. And so here, once again, even though she's lost her job, she's going to need to employ the same sort of strategies and tactics to win her unemployment claim and show, no, this wasn't willful misconduct. So like kind of thinking about some of these strategies, maybe a screenshot of the traffic map showing that there was in fact traffic. That's not willful misconduct. A record of her phone call. This wasn't no call, no show. She tried to call. And then some of these other things were what I mentioned before, if she's trying to prove unlawful termination, kind of this journal of experiences and witness info, past performance evaluations, those kind of things. If your employer refuses to pay you the wages you're owed, or doesn't follow other types of laws, they are violating, they're potentially violating federal and Illinois laws, as well as Chicago laws for workers in Chicago. Employers can be charged with misdemeanor offense, fines, and other penalties, in addition to being required to pay unpaid wages to workers. Workers can file claims for payment with the U.S. Department of Labor or the Illinois Department of Labor. And while all workers have the right to be paid for the work they perform, immigrant workers who are unsure about their work authorization status should only file complaints with the Illinois Department of Labor, not the federal government. That is not a safe way to enforce your rights anymore. It is against the Illinois law for an employer to retaliate against any worker for exercising their rights, filing a complaint, or cooperating with an investigation. Here's a list I've made of some of the important strategies for protecting your rights on the job. As you saw with each of the scenarios we discussed, you must collect important information about your working conditions. Even if your employer is treating you well and you don't have any issues, working conditions, as well as managers and supervisors, can abruptly change without notice. And so it's vital that you're prepared with your records and documents at all times. And so this list is in the resource folder, and it's certainly not exhaustive, but it has kind of just helpful things to gather about your work, your workplace, your employer, as well as information that you should gather should you experience a problem at work. Record keeping is obviously a must-do practice. I've mentioned that a number of times. I think that kind of broadly, there's two ways to enforce your rights. Like using this example of combating wage theft, first method involves strategies you pursue on your own. So these are individual methods that include filing complaints with either the Illinois Department of Labor, the U.S. Department of Labor, or the Chicago Office of Labor Standards for workers in Chicago. The second method involves strategies that you pursue with your coworkers. It's often more effective to use collective methods to combat worker rights violations like wage theft. And so the Illinois Department of Labor's website, as I mentioned, is just full of amazing resources. Very easy from the homepage, labor.illinois.gov. Click on employees at the top ribbon. You'll be directed to a webpage where you can file your complaint. You can make complaints in English, Spanish, or Polish, and you can make them online or by email or regular mail. And then there's also these links to these other important places with Illinois government agencies that enforce worker rights. It also has links to other organizations that provide legal assistance. There's legal aid, all sorts of different helpful resources. As you will see, when you prepare to file your complaint, folks at the Illinois Department of Labor also want to see the evidence you've gathered to support your claim. I cannot stress this enough. Record keeping and documenting working conditions are essential strategies for enforcing your rights on the job. There are always risks or disadvantages to taking action to combat wage theft and other violations. When you're acting on your own, you're at greater risk of retaliation. While retaliation is obviously illegal. Sometimes employees experience retaliation disguised as something else. But joining together with your coworkers, you certainly could face a similar risk, but organizing as a group can protect you. And here's just a couple of good examples of like Department of Labor in action, and just like the very real money that's being recovered for workers. Just very quick, so I know we're running out of time. There are lots of different agencies throughout Illinois that workers can turn to when their rights have been violated. Different agencies address different concerns and enforce laws in different geographies. Each agency also has a time limit for how long after the incident one can still file a claim. So here I've listed some of the federal agencies, the rights, and then the time limit. Here are Illinois agencies. So it's important to notice that like for wage theft violation, you only have 1 year after wages were initially due. And then in Chicago, we have additional office that enforces these laws. There are also all these like great resources out there. In particular, I'm thinking about worker centers. They are community organizations that provide support, information, training for workers. So if you're dealing with an issue at work, this is another place you can turn to. And the logos I put here are just a few of the worker centers that exist in Illinois. And then I also want to point out that from the Bureau of Consumer Protections and the Chicago Office of Labor Standards, you can find out all this additional stuff about creative worker rights. And so they have some pretty cool resources, and I like love that they have this Art is Labor logo. So I would just put it there because I think that it's probably a lot to explore. I saw Sasha's name on their advisory council, so it's obviously legit. And then just to finish off, here's a few more readings and videos. There are handouts that are in the resource folder that have copies of these complaint forms, and then that list of record keeping and documentation. I'm just ending with this photo because I love this photo. If folks haven't been to the Groman Museum in Milwaukee, I highly recommend it. Just take the train up there. It's a museum of work and workers and art of work and workers. And this one I really like because of just like the irony of the photo and all these workers lined up in a line for food assistance during the Great Depression. But anyway, admission to this museum is like next to nothing. It's like $3, and it's an awesome resource. So that's all I got.
Thank you so much. This has been amazing. We have a bunch of questions. Should we just kind of go through them?
Yeah.
Okay.
I'm listening. I'm just grabbing more water. I'm listening.
No, yes. Do what you gotta do. Okay, the first one is how far can employers go with that line we've all seen in job descriptions, other tasks as needed or assigned?
I mean, I guess it really depends on the occupation and industry. And it depends on whether or not you're covered under collectively bargained agreement. Sorry, that's a really not helpful answer, but I think so much of this stuff is industry specific. But for most salary jobs, I think that they can pretty much do as much as they want.
Next question. Can an employer, either an LLC, a nonprofit, individual, escape liability for failure to pay workers by filing for bankruptcy?
You know, from what I understand about bankruptcy laws, you've got all like the line of creditors or different entities that are owed money. And I know that workers represent one of those groups, but they are way low on the list. And so, yes, it is not an escape, but I think in reality, it takes workers a very long time to recoup that money if they do ever recoup it.
Another good thing to come to us for if you're having issues on that. And this question is for both of you. How can advocates, donors, and institutions help artists and arts workers empower themselves and gain more access to justice and worker rights? Big question.
Certainly ongoing education, and taking responsibility, I think, empowerment starts with education and making the choice to inform yourself and to share that information with others. So continue to come to these webinars and programming. I'll also say that Arts Alliance our wheelhouse is, and our focus is being able to connect our arts advocates, to build arts advocacy, but also to connect advocates with state lawmakers and your electeds. And we had our Capitol Day back in April, but through the rest of the year, and I think with a focus on late summer through the fall, Arts Alliance is planning to organize and support our arts advocates, whether you went to a Capitol Day or have not, to meet with your state electeds in district. And it's in those conversations, especially when you come together with other arts advocates in your district, to address some of these issues. And I think to speak about, especially if you've tried to tap into something like the Freelance Worker Protection Act, or if you're just noticing other issues as an artist, as a creative worker, and making those issues known. And Arts Alliance is here to back you up on that. Allison, I don't know if you have other.
Oh, yeah, I think
Yeah.
that's a wonderful response. I just want to say real quick, I put a list in, or a link in the chat once again to a very brief form that folks can fill out. And if you do, then I will email you this link to the folder with all the resources and the slides and stuff.
Yeah, thank you. And I will say too, we do programs on lobbying and advocacy for nonprofits. So if you are a nonprofit organization who wants to advocate for better worker protections for all workers and arts workers, we have a recording of that program. We do it every year, and we also partner with the Arts Alliance on that session. Yeah, I think as a donor, I would just recommend, if you are a donor to an arts organization, asking what the arts organizations, what worker protections they have, and making sure that they, are treating workers well, and maybe doing beyond the legal minimum is always good too. We're talking a lot about the legal minimums in this program, which, sadly feels like something to strive for often. But I think as creative people, we can imagine something better and more holistically good for workers in our state and our city. So, yeah. Okay. I think that's all the questions. Thank you so much, Allison. This was really, really, really wonderful.
Oh, you're very welcome. Please, folks, happy to follow up offline if you have any other questions or issues.
Yeah, thank you. Just look for that email from me later on, probably tomorrow, hopefully tomorrow, if not on Monday, with the video recording. I'll also include all the links that I dropped in the chat, including that form to the Google Doc for more resources from Allison. So please fill that out to get more. There's a lot in that folder. And follow up with any questions that you have for any of us. We're happy to help, and really that's what we're here for. So take advantage.
Absolutely.
All right. Last thing, there will be a survey that pops up as you leave the Zoom. Please fill that out. I read every single one. They are very helpful for us planning, programming, and deciding what's next. There's also a drop-in question that you can kind of add whatever you want. So if there's a topic that you want us to cover, if NDAs or non-competes, were a big issue for you and you want us to see a program about that, feel welcome to drop in other topics and stuff like that. And I can put my contact info in the chat here. Sorry, somebody just asked for it. It will also be in that email because it will come from me. But there's my email. Yeah, reach out anytime you need to. All right. Thank you all. All
Awesome. Thanks, everyone.
You.
We'll see you soon.
Thanks so much,
Thanks,
Allison.
Thank you, Allison. Take care, everybody.
Bye.